Suzette Kelo, the named plaintiff in the case, she had just bought her home about a year before the takings commenced in New London. It was the first piece of property she had ever owned in her entire life. That place was incredibly important for her. It was something where she was really going to start a new chapter in her life, and she poured her love and her labor into that property. She wasn't there but for about a year. She got a knock on the door telling her that the New London Development Corporation was interested in purchasing her home for a new development project, and if she did not sell, it would be taken through eminent domain. Right up the street from her was a woman by the name of Wilhelmina Derry, who was in her 80s, who was born in the home on East Street in Fort Trumbull in 1918, had never lived anywhere else. Her family was right next door to her, and she wanted to live out her remaining days in this home. Somebody who had a very deep attachment to the property, as contrasted to Suzette, who was a newcomer, but both of them valued home ownership and property ownership to such an incredible degree. And that is recognized in the Constitution's protection for private property rights in numerous provisions of it. The Takings Clause just simply does not say, nor shall private property be taken without just compensation. It could just be that if the government wants to take your property, they pay you for it. But there's an added level of protection that was at the heart of the Kelo case, is that it can only be taken for a public use because of how important property ownership is to people like Suzette Kelo, Wilhelmina Derry, and to so many others throughout the country. You know, one of the things that happened when we got involved in the Kelo case is that many critics claimed that the only real reason why there was so much controversy about this was because IJ had this incredible public relations machine, and that we steamrolled the city of New London in getting the word out, and only if the public would have known all the great benefits that would have flowed from this project, it would have been a different story. Well, obviously, we make no secret about our ability to talk about our cases, to get the word out about our cases. But I just simply think that that is not true. People saw this case as an injustice, and they did so for a couple of reasons. One is that they looked at Suzette Kelo's little pink house and said, that's the house I grew up in, or that's the house I would like to own someday. That's the house that my family members live in. It really, this case hit home in a way that very few, literally, that very few constitutional decisions really do. The other rap that people said against the case is that, well, what's the big difference between taking a home for a new private development project or taking a home for a road or a reservoir or some other type of traditional public use? Well, there's a huge degree of difference between the two, and I think people instantly got that. It's one thing, yes, it can be difficult to give up your home for a public works project, but for a government to tell you that we're going to take your home or your business and we're going to hand it over to another private party, essentially somebody who's just like you, except that they happen to have more money than you do. And we think that these new owners will provide more tax revenue and benefit the community more than what you are doing. That is deeply offensive to a vast majority of individuals. And I think it's one of the reasons why people were so shocked when the court upheld these types of takings, to take property as what was at the heart of the Kelo case from one private owner and hand it over to another private party, in the hope that that new private party would put the property to higher and better use. The Constitution says that private property shall only be taken for public use, not private use, and yet that is what the court signed off on in this case. Kelo also today remains a very powerful teaching tool. I've heard over and over again from law students that have come into our programs that it is talked about in law school. It is one that resonates deeply with students and with members of the public, and it provides such a great launching point for discussions about some of the very fundamental notions of our Constitution. It is something that folks really want to talk about. It raises issues of the limits on government power and the proper role of urban planning, the rights of the individual versus the community. Let me talk just real briefly about some other points that Wes made, and then a few other things as well. Wes talked about wanting to get away from the bright line in constitutional law. Well, I obviously disagree with that. And I think the takings clause is one of those areas where you actually have a fairly bright line. It is one of those provisions of the Constitution that has a lot more substantive meaning and a lot more obvious meanings than many other aspects of the Constitution. For instance, what does due process mean? What is an unreasonable search and seizure? Public use actually has some real meaning, and Justice Thomas's dissent in the Kelo case talked about the history and the meaning of public use, and it went through, obviously, public ownership of property, and then also things like railroads and utilities where people have an equal right of access to the property through things like common carriers. Those are pretty easily defined. And it's pretty clear that a public road is a public use. Costco is not a public use. That a reservoir is a public use, but a lifestyle center with retail stores and condominiums up above is a private use. So I would say that in most of these cases, obviously there's going to be a couple of tough calls on the margins about this, but there is real substantive meaning to what public use is, and that you can quite clearly draw these lines. And if you don't draw these bright lines, you get into a situation where you have a vision of eminent domain without really any meaningful limits whatsoever. And that is what happened, as an example, in the Kelo case itself, where obviously Pfizer was directing a lot of the project. There was a quid pro quo, really, where part of the agreement of Pfizer coming to New London was to revitalize the Fort Trumbull neighborhood. But obviously, folks in the city council thought they were doing this to benefit the community. And this is always going to be the case, where you think that the so-called trickle-down effects of private economic development in the form of higher tax revenue and more jobs, if that is a public use, then obviously you want to give every benefit possible to the private company that is coming in. You want to cater to their wishes. You want to mold the development plan to what they want. New London had the approach of what is good for Pfizer is good for New London, and it would be very hard to separate those two out, even in instances like Wes was referring to, where you have a one-to-one condemnation of property. The city could very easily claim, well, this new owner that we're giving to, whether it's the Walgreen for the other drugstore, or a case like the 99-cent store case from California, where they were going to give a 99-cent store for Costco. Well, why did they want to do this? Well, because Costco was the largest taxpayer within the city of Lancaster, California. So that is something where if you do not have that bright line saying that takings for pure economic development are unconstitutional, you're really embracing a vision of eminent domain without really any sort of limitation whatsoever. If you don't have the bright line, there is a doctrine, and I will close with this, that comes into play that should have come into play, and to a certain extent did in the Kelo decision, and one that we would like to see revitalized in in eminent domain law, and that is the doctrine of necessity. That the government should be required to show, whether it's in private takings or in public use takings, that the takings are actually necessary to accomplish the public use. We were able to demonstrate that in the New London case. We proved that all of the development that New London wanted to do could have occurred without taking any of the homes. Ilya and Professor Epstein mentioned the Italian Dramatic Club, which was just a naked example of political preference and how this could have really been done. All the properties had to go except one politically popular private social men's club in the redevelopment plan was miraculously saved. You know, Fort Trumbull was originally a largely Italian neighborhood. A lot of the people that we represented still had that background. As Matt Derry, one of our clients, quipped, the New London's attitude was, the Italian Dramatic Club can stay, just all the Italians have to go. That was his take on it, and that is absolutely the case, and it shows why, in so many instances, that development projects can occur without taking the land of the folks that truly want to stay. This happens throughout the country. If we had judges that really took the doctrine of necessity seriously and looked at this rather than just rubber stamping whatever the government wants to do in this area, like they had done for years on the public use question, you would see a reining in not only of some of the abuses in private condemnations, but in public use condemnations as well. We just close by saying that the real legacy of the Kelo case, and I think it is fair to say, and we hope, and one of the things we are working for, is that ultimately Kelo will be overturned. But the real legacy for the property owners in New London is that even though they lost their homes, they led an effort, and their fight was not in vain. It was an effort that fundamentally transformed the law in this country, attitudes about private property ownership, and it's allowed so many other folks that for years had fought really a hopeless battle against these types of takings to really give them some strength and support to fight these sorts of condemnations, and we hope that that will continue, and we at the Institute for Justice and other folks will make sure that private property rights are restored and these types of unconstitutional takings are stopped.